floods. I have an alarm that goes off, but then I have to take another meeting, and I'm like, oh, but happy to be here today.
Sorry, everybody. Thank you. My coffee was all the way down on my counter. Okay, so let's just start. We do have 3, so I would just note for the record, we do have a quorum with you, Josh, and Tashonda, and of course, if Gina shows up, that's just a bonus. So with that, I just want to note that a copy of the September 12th meeting minutes have been posted. So if there are any corrections, additions, anything of that nature, speak now or forever hold your peace. Hearing nothing, I will declare them approved. So last time around, we were talking about the reconsideration process and other remedies. And Tashonda, since you are here, I think it would be helpful. Josh, I think you were potentially working on some stuff, but with Tashonda here, if we can launch right into the accountability piece, I think that would be helpful. And so to start there, and I'm sorry, Tashonda, I'm looking for my notes from the last meeting because I know we were throwing out some ideas. And now I just don't remember where I put them, because I thought it would be helpful for you to know some of the things we were talking about.
Madam Chair, as I recall, one of the major ideas expressed was, I forget what it's an analogy to, but essentially that if someone sues and wins for wrongfully being disqualified, that they'd be entitled to attorney's fees or some measure like that. The sheriff officer's concealed carry permit, I think.
Yep, that's right.
Yeah.
Yep, and I did find it. And I know I had also thrown out, not only attorney's fees, but also any lost wages. That was just another idea. I did find my notes. So Tashonda, I know, last time around, we definitely talked a little bit about some other options were even just in our report, highlighting just the disparities that we have seen, and of course, how important that is. I think it's important to always note that and to make sure that that is highlighted. And then I understand that's not necessarily change, but I do think at least recognition is important. And then from there, we also talked about some other proposed options. Could be some sort of a community oversight board or a legal oversight board. Both Josh and I guess kind of talked a little bit about some difficulty with piercing the qualified immunity, that's going to be, I think, just a difficult piece to even start. So other ways to perhaps chip away at this, if you will. So Tashonda, that I think pretty much gets you up to speed from at least what we started talking about. And then here we are.
I've never, as far as that's really great progress. And again, my apologies for meetings that I missed. Qualified immunity, can you speak more to that? I've never heard of that.
Yeah, so, and Josh, if I'm getting it wrong, it's been a while since I've actually had to talk about it really, but essentially it's a legal immunity that is afforded to government workers, understanding kind of the job that they have and the positions that they are in. And it is, quite frankly, just a difficult burden to overcome, that they are presumed essentially to have immunity for the work that they are doing. And it's just by case law, and I think the way it's enforced in the courts is it is just it's difficult to pierce that qualified immunity. Is that, I know that's a very short summary, Josh. I wasn't.
Yeah, what I think that's exactly right. But I think, like, to conceptualize it, Tashonda, think of it as like a shield that government agents get in litigation if they are sued for doing something wrong within the course of their work. Before the case gets to the merits, like before a judge or a jury would even decide if the person who's claiming that the government did wrongdoing was right or wrong, the government gets to bring gets to raise this defense of qualified immunity, where essentially they get to say, unless the thing that the government agent did violated a clearly established constitutional right, then the case gets tossed out of court altogether. And in practice, this creates a really high burden to even get over that sort of initial threshold anytime someone is suing the government, because you need to be able to show that whatever they did was wrong is something that essentially another court previously has already said that is wrong, and they should have known that they shouldn't do it. And so it sort of puts this really high burden where you have to almost show that they like knowingly did something wrong, not just that they were sloppy or that they made a mistake. So it makes it really hard in practice to bring a civil lawsuit trying to get damages for a constitutional violation from a government agency. And it's a legal doctrine that was established by the US Supreme Court. So there's really nothing that we can do in this subcommittee that's going to get around that in terms of, again, allowing someone to directly sue DHS or any government agency and hold them accountable that way. So what we were brainstorming in the last meeting are other things that we can do that would help somebody who's been wrongly disqualified bring their case and prove their case and access a remedy that way. And then anything that we could do, to sort of create some skin in the game from the part of the agency. And so that's where the ideas of attorney's fees came up, and other statutory lost wages provision. Kind of the idea with the attorney's fees would be, well, first of all, that it helps somebody access the sort of standard appeals process, because they can potentially get an attorney on like a small retainer, and then the attorney can look at it and say, hey, if I think we've got a good chance of winning this case, and they go through and they do win the case, then the attorney can recapture all of the fees that otherwise the individual would have had to pay from DHS. And so it increases people's access to legal help, which is good since this process is complicated. And then also, does put some skin in the game, because potentially the government would have to pay for your lawyer if they wrongly disqualify you. And then lost wages is another provision that Lucas thought of. And both of them are things that exist elsewhere in Minnesota law, for other sort of analogous discretionary decisions that state agencies made. So we thought that they would be, a relatively easy lift to sort of point to how these other statutory schemes work.
Thank you. Thank you for that breakdown. And yet again, another loophole to perpetuate.
Yeah.
And I definitely understand, in regards to the timeline we have with this task force, it limits a lot of what we can do, and especially something that has been established by the Supreme Court. I just wonder if it would be worth us looking into like the reasons that the qualified immunity was even proposed in the first place, because I'm sure that there are some commonality that that we could look at in regards to potential remedies for the task force. Is one thought I have. Another one is I know this is set from the Supreme Court. However, a lot of the actions in the name of "this is my job" are being done in a manner where they are taking away a person's right to due process. So that's why I thought that was definitely verbiage and a focal point in regards to the accountability. Those are just some initial thoughts with the qualified immunity. And I know there were some other suggestions that I had given prior to. I know Lucas, you kind of had went over one of them. Let me see, it was when a constituent is accused or charged with a crime or disqualifying event, administrative evidence against them should be immediately provided to them, no later than when action is taken against said defendant or accused. Because when we look at the attorney fees, look at having resources for attorney fees and loss of wages, what have you. A lot of the issue is that the departments are not responding in a timely manner, so that once the person has appealed or whatever actionable steps they've taken to clear their name or to try to understand what's going on, that short 10-month statute of limitation has surpassed. Because it's only 300 days that you get to file a claim against a governmental department, which, I feel is intentional of why it takes so long for the process. Because then once people do win their case, they can't then go after said department because the statute of limitation has already expired. The other thing is administrative disqualification process should be finalized in a more timely manner, statutory timeline. So that was more so in regards to, that was speaking to the first point. And then also, I know with HIPAA, there's access that we wouldn't have in regards to employee files and things of that nature. But there should be some type of route we can look at in regards to disciplinary action that can happen, whether it's just making it more clear as far as the grievance steps or creating a new process for that. And then lastly, yes, with the community advisory bodies or community review board, however, applicable agencies should not have the authority to regarding said committee's membership. Most of the advisory committees or community committees of whatever department, that department's commissioner is the one that's over the membership. That's very problematic, because if you have a committee member who is outspoken or not going along with the status quo, then that department just simply kicks that committee member out of that committee. And if you don't know, that personally happened to me with the Department of Human Services. So that's something I've expressed that I'm willing to go into more in depth as much as we need to. And that's with the current commissioner. And I have all the documentation.
No, and I appreciate all of those comments and your thoughts. It seems to me, one kind of first thought, I guess, to Shonda's, I think we could see if there's something we could just share with the group as to a little bit more about qualified immunity. See if we can kind of scrounge up just some sort of an article. I do think it is the type of thing that, and I don't want to sound like I'm not listening when I say this, but I think just having worked on cases before where there is qualified immunity, I can just sort of say from experience how difficult that is. And I think, if we're trying to balance what we would want approved from the legislature and what we can really challenge, sort of where to focus our energy, I think would be good. And so definitely happy to explain more on it, but I think what you talked about, I think there's some really good ideas in that to me, it kind of makes sense to perhaps we can sort of finalize a few remedy ideas. And then some of the ideas you proposed, I think are great ideas for the actual process piece, which is what we wanted to talk about after we're done talking about accountability. So I think some of that, they're great ideas for that actual process, like actually providing individuals with the information upfront so that they can see what's there, which then would help, let's say, with an attorney reviewing of if they're going to take the case and things like that. So I feel like there's definitely I feel like we have a lot of really concrete, good ideas. And as far as community review boards and being kicked off, I'm very sorry to hear that happened to you. And I don't know how much this task force is really able to, I think to me, it would be a good suggestion on our part to say a community review board that is independent. And then in some hands, maybe we're leaving that in the hands of the legislature. And Jean, I mean, you have more experience. I'm not sure. I want to make sure we also stay within the bounds of kind of what we've been tasked with. But I know in other areas, we've definitely talked about kind of, sort of proposing, hey, legislature, here are some ideas and thoughts for going forward, even if it's not something that's directly from this task force.
Yep. Yep. Community review boards, I think, is a little bit outside of our scope. And so we could recommend them looking at community review boards as part of the process of appeals or whatever, but I don't know that it's in our scope of what we're doing. So, yeah, I don't know how far down that rabbit hole we want to go.
Yeah, and I definitely, Tashonda, I can definitely see if I can find something a little bit more on qualified immunity. I worked at a firm years ago that did some of the federal cases that had that. So it's been a while since I've actually really had to look at it, but I'm happy to definitely get something more to just describe it to you. But I do know, at least from my previous time having to research it, that from the plaintiff perspective, that is just sort of an acknowledged difficult thing to even start with. And so definitely happy to, but I also want to make sure that we don't get too bogged down in something that, I guess I'd love to focus our time on really concrete and constructive ideas like the providing evidence up front and things like that I think are good, solid recommendations that maybe can get some traction with the legislature and kind of go from there.
Yeah, it's just, when you think about these are all hot terms now, healing and anti-racism and all of that, you really can't heal or go forward when the accountability isn't there. And this is just, the deeper you get into it, the more and more you see these loopholes that just perpetuate it. And I wonder if it is within our scope to look at some type of infrastructure assessment. I know this is something that we brought up with the larger task force, but just the mere fact that there's data that should be captured either is not, or there's data that it's just all over the place where DHS, and I imagine other departments cannot readily pull it up. And if they can't readily pull it up to provide to a task force, that's very much indication that it's something that they're not regularly reviewing, which is highly problematic.
And I definitely agree with that, 100% Shonda. I think being on this has been an eye opener of how much data is either not collected, not stored in a single place, whatever that might be. And then nobody knows. And I know I keep going back to it's just, and it's not necessarily our task force, but it was the predatory offender one where the report noted that Minnesota does not data on people who have to register as a sex offender from their juvenile offenses. I mean, just things like that, and I think there was something else, and we were just talking about this in the disqualification subcommittee that I had brought up where it was not clear to me that the data was actually tracked. And so I've already forgotten what it was, so I apologize. But yeah, I think that's an important idea.
What if along that line, like kind of how the Sentencing Guidelines Commission has to provide an annual report to the legislature that tracks all of the statistical data on people who are sentenced for felonies. Another idea for accountability could be to require DHS to report to the public, information on disqualifications, racial disparities and disqualifications, like a bunch of the information that we're getting, handpicked for us for this task force. To Shonda's point, is there any reason why we shouldn't have DHS report that annually? And think about if they did, how much easier that would be for us if we were able to look at the last 15 years of reports.
Yeah.
We've only been working for 2 years.
Yeah, I think that should be one of the first points that we make in the report, is the fact that it took 6 months to get 2 years of data, and the fact that DHS isn't able to like readily pull data about background studies, about racial disparities, about I think, regardless of whether we have solutions, right, or like recommendations about that, like the fact that letting the legislature know that therein lies the problem, right? If you're not tracking data, how can you know we're so like that? And they know across systems, DOC just asked for a bunch of money for data tracking because they know that there are issues, like minutes has problems, right? And so I think just naming the problem in the report is going to be a good idea, because what is the solution that we're asking them to do? Like, what is our recommendation around that? Do we have one?
Well, I think
that's what I'm saying is maybe one of our accountability recommendations is annual reporting.
Oh, okay. Yep.
Because Gina, you might not know this, but the Sentencing Guidelines Commission, well, the Sentencing Guidelines Commission for sure, but they have, they publish that data every year on how long people are sentenced for, what they're sentenced for, what the racial disparities are, all of that stuff. And it's really useful. And it just, it creates a public record of what the judicial system is doing, in that little area of government decision-making. But, nothing like that is happening here, and it certainly could. And I feel like, Shonda's been.
Do we know that, Josh? Ms. Cassane, is there a report that goes in? Is there reporting in this area to anyone? Do we know that is true, that there's not? I just don't want to make any assumptions, Josh.
I haven't
Madam
seen
Chair, Vice Chair Evans, I am not aware of any annual report, and I can certainly check to make sure.
Okay.
And it's, for the Guidelines Commission is sort of a pseudo agency like DHS is, but it's created by the legislature, and it has that reporting requirement created by statute. But just to finish my thought, Shonda's been such an awesome advocate for this accountability idea, something that goes above the process fix that we want. And so I really want to be able to come back to the main group with at least a few concrete recommendations
Yeah.
that fulfill that. And I feel like annual reporting, attorney fees, possibly lost wage recovery, you know, those aren't perfect, but they're concrete things that push in that direction.
In regards to the attorney fees, I did want to make mention too that there's some prestigious law firms that I've been working with that have switched their focus in regards to their pro bono hours. Where, like for example, there was one that had a lot of hours that they committed to the Minneapolis Police Department, and in the aftermath of the murder of George Floyd, they've shifted those focuses to doing more community, more hours to community.
Tashonda, you're breaking up pretty bad. Is it just me?
No, I can't hear her.
No.
Assistance in regards to with landlords and mortgages.
Tashonda,
Is
you
it better?
broke up there for a second. I'm sorry. I heard you were talking
this
about some
better?
larger firms, yes, shifting from like the Minneapolis Police Department to, I think you said more community based, and then I think you started to kind of cut out a little bit. And the last thing I heard was landlord tenant. So
Sorry
no,
about
that's
that. Let me
okay.
know.
I want to make sure we hear
Let
you.
me know if I cut out again. No, there have been some law firms that have shifted their pro bono hours to more community, to utilizing that for community members to utilize those pro bono hours. For example, with the COVID relief and helping those that have been evicted or facing eviction. Because their efforts were more so used with by the Minneapolis Police Department. This was a result of
I'm not like
Yeah.
able to get any.
Tashonda, we
George could be
can't,
in there where
Tashonda, we
and
can't hear
can
you.
have pro bono hours.
You guys, I gotta jump. I got 11:30 today. I have 3 meetings at the same time today, so I gotta get off today. Thank you for the conversation. You'll be well.
Hey,
I
Gina,
do as well.
just-
Not sure.
Wait, can I just get Gina for like 30 seconds?
Yep, what you got?
So I put together an outline of issues for you know, for the reconsideration process discussion. You know, especially not having you, can I at least email you that and get your thoughts on it?
Yeah, I think I heard Tashonda may have to leave too.
Okay.
Did
Yeah,
I
yeah.
hear?
I'm
Email
not
it to
sure. I'm not sure what's going on with my but yeah, I can email what I was saying as well to you all.
That would be great.
Yeah, not sure what's going on here.
Yeah, if you send me that in an email, Ms. Williamson, I can forward it to the whole group.
Okay, thank you.
Thanks.
Perfect. Sorry, I got to run, you guys. This is something I can't miss today. I got my work stuff. So,
We get it.
We get it.
all right.
Bye,
Bye, you
Gina.
guys. Yeah, email that to me, Josh.
Okay.
Well, and it looks like we lost Tashonda too. Well, Josh, I can listen to you, or if you want, we can find another time.
Well, why don't, I mean, I can't remember, is this our last meeting or do we have, yeah, this is our last meeting to shore up what our bullet points are going to be, right?
I think technically, but now we don't have quorum.
I mean, for purposes of quorum, I'm just noting who came in. I'm not noting who goes out, unless you officially call for roll, Madam Chair. There was a meeting scheduled for October 10th that is after that 7th task force meeting, though.
But so I just think we need to be conscious of our public accountability duty here, and not adopt any official decision from the subcommittee when we are not when we're not online.
Yeah. So here's what I would say, Josh, I guess if you don't mind, and this might be partially selfish of I know you put together the work. So I don't want that to go to unrecognized, but I'm scheduled to start 2 jury trials starting next week. So even if we have the one on the 10th, I'm worried, if I'm in a jury trial, I don't know, obviously, I mean, it's the Hennepin cattle call. So our meeting at 11, it's possible I'm still available. But that might just be helpful in case either I'm really short in there, I can then just sort of say, hey, here's what I think I would vote, where my thoughts are. It's up to you, Josh, or it's 11:30, we can call it. I'm open.
I'm sorry, I'm not quite sure I follow your suggestion.
So if you don't mind, if you have some specific thoughts that are prepared, I'm happy to discuss them and hear them now.
Yeah.
While we're still here and use some of our time still.
Oh, yeah.
And then that way, then also if, let's say on the 10th, I've got, I get the unlucky, hey, 9 o'clock, be down here, we're ready to start, you guys. You at least, I already know what you're saying, and at least I can say my thoughts and stuff like that.
Okay. And can we wait till the 10th to adopt our bullet points?
We're going to have to. I think, so here's the thing, and I think the task force meeting on the 7th, although because we've never had a full, at least my calendar shows a meeting on the 7th and the 21st. Is the plan that somehow on the 7th, we're going to vote on all recommendations?
No, but I think.
Because we have to do that at some point.
Will correct me if I'm wrong, but I think there was supposed to be some time to discuss them, and like some committee members need to go back and get approval from the orgs that they're representing. So I don't think that is for the 7th, but I do. Did they want us to have our bullet points finalized by the 7th?
My understanding, Mr. Esme, is you're essentially correct.
Is there any way?
I think finalized is essentially what the task force wanted, but it's not a formal thing to be voted on. It is to give some time for the parent orgs to mull it over.
Is there a way? Is there any way that we, the 4 of us, can like finalize this last bit via, we'll still talk about it today, Lucas, but like we don't have Gina, we don't have Tashonda, and we do need to like adopt it as a committee. Is there any way we can do that via email before the 7th, or would that violate the rules of our public discussion?
Mr. Esme, if I'm going a bit out on a limb here, but my understanding of the spirit of the open meeting law would be that any discussion that leads to a decision like that would need to be publicly available. So, for example, the email thread would need to be posted to the task force website or something of that nature.
So,
but we could do that.
Yeah, I think.
Well, because the other, I guess, thought is like, do we want, so Fridays at 10 although I know Gina has alternating meetings, if I remember correctly. Because my other, I guess, just throwing it out there, would be just a short meeting on this Friday at 10. To potential, if like, as long as we have enough to make quorum, if that's enough to, Josh, you and I talk about them today and maybe just have 30 minutes on Friday.
I could do that.
And, Josh, you and I can kind of fine tune them a little bit so that then on Friday, if we're just here's the thoughts, let's, get it done.
Yeah.
If
we'll
send that to the group. I'm technically supposed to be at it's just a CLE, so I can step out to do this.
Okay.
I'm sure I'll want to break from it anyway.
So yeah, I could send out a meeting invitation for, that would be Friday the 30th at 10.
Yeah. Yeah,
Okay, and we
Yeah.
should have staff availability for that time as well.
okay.
Yeah.
Yeah, if you maybe email first and see if that works, and then if it does, let's get that on the calendar.
Will do.
And then I know there was that other woman that was willing to come, and maybe we still have her come on the 10th. But at least we'll, maybe she'll give us some information that we can use in the final report writing with our bullet points, but yeah, if that works, I think that's a good idea.
Sounds good.
Okay.
Plan.
All right, should we jump into the
Yep.
outline then?
I'm ready and I'm listening.
Okay. You seeing my screen share?
Yes.
Okay, so this is just kind of my, my brainstorming, process issues, and thinking about things that have, trying to remember things that have come up that we had like earmarked before. So each bullet point is a potential item, not necessarily that we'd make a recommendation on, but like something that at least I thought we should discuss. And I might have missed stuff, so if I did, Lucas, feel free to jump in. So one thing that had been bugging me, and actually the thing that like took the longest for me, like combing through the statutes to try to figure out, is why some people get an administrative law judge and other people get a DHS judge. And I think it just comes down to what the position that they are disqualified from relates to. So if I'm understanding the statute correctly, essentially you get an administrative law judge if it is child and foster care, or like a residential or non-residential like treatment facility, or like group home, like those types of things. And then you get a DHS judge if there's anything else. I don't know necessarily that we need to change that. It's just always been something that to me seems odd that it's not consistent, and I don't know why it's not consistent. I don't know that there are huge implications for a petitioner depending on whether they end up at an administrative law judge or a DHS judge. The one that I could identify is, I think if you have an administrative law judge, your only remedy after that is the Court of Appeals. Whereas if you have a DHS judge, you have the option to go to the district court or the Court of Appeals. I've only ever had cases that went to the ALJ. So I don't actually have experience with a DHS judge, and I can't really compare the two. Excuse me, I'm recovering from a cold. So I don't know that I have a strong opinion on what, if anything, we should recommend on this. But it is something that creates confusion and makes it, I found it, when I've worked on these cases, I found it difficult as a practitioner. I can't imagine how much more confusing it would be for an individual. So that is what it is. Do you have thoughts, Lucas? I mean, if we could just do nothing with this and leave it.
Yeah, the only issue I have in this, I'm like trying to remember back to administrative law in law school. But I don't know with the ALJ if that's technically administrative law. I don't know if then we'd have to go through the whole process to change, the whole administrative public comment process, like that whole administrative process. That would be my only.
Well, the remedies, I did list out the statutes that create the remedies. So those are statutory, whether whether it points you to the ALJ or whether it points you to DHS.
Okay. Yeah, I mean, and I guess to me, the only thing is it would be nice. The only thing I can think of it would be nice if it's a similar appeal process. I get it, even if you're appealing to the district court still has to almost act as a court of appeals. Although I think Under some situations, is it de novo review versus abuse of discretion? Do we know that one?
I think it's always going to be abuse of discretion.
Okay. Because even if you don't agree with the district court, you can still appeal to the Court of Appeals. So,
Yeah, you get an extra bite at the apple if you have a DHS judge.
yeah,
But I also wonder if an ALJ, they have a much broader set of issues that they look at. They might, you might be more likely to get an ALJ that might look at an issue with a fresh pair of eyes compared to a DHS judge, but I don't actually know that. I'm, completely speculating there.
well, I just know in the the foster care and daycare license pieces that I've looked at, I've even though it's the ALJ process, I have felt like there are more options, even let's say for settlement, than when I'm anything in front of a DHS judge. So because they can do like correction actions and things like that. I don't know, there's a part of me, it might be nice to make it similar, but at the same time, there's still due process.
Mhm.
So do we really touch it if there is still due process?
Well, let's just leave that as something to think about.
Okay.
So the next issue is the timing that an applicant has to appeal after they've given notice of the disqualification. So it's a really fast turnaround. It's in some cases it's 15 days, in others it's 30 days. I think it is yeah, so it's usually 30 days. It's 15 days if it is. Oh, if the agency finds that there's a particular risk of harm.
Okay.
So, I've definitely come across a lot of people who can't get the appeal in that quickly. I do anecdotally know that DHS has from time to time been pretty flexible with this. If people are like relatively close, but outside of it, they'll go forward. Although I don't think that's something that they always need to do.
I guess I would love to see it at the 30 days. 15 days to do any sort of an appeal work, especially when you're expected to provide documentation, to me is just not practical. And I also know, it definitely depends on the agency you're working with, because I know, and I get it, this is outside of the disqualifications, but I've talked about at our prior meetings how on maltreatments, some of the stuff that I've seen where they're trying to look at mailbox rule and things like that to knock out quite frankly, to me, it feels like any appeal they can knock out, they do. And so to me, and I think, are there good cause exceptions for any of those?
Not listed in the statute, I don't believe.
Because I would like a good cause exception. What if I had someone one time, what was it? Whether they were hospitalized or in a treatment center, and so it went to their address, but they weren't there. And so, even just think about COVID, where mail was slow. Everybody was stressed. Nobody knew what was going on in life. But I guess I would like a good cause exception for the request for reconsideration too.
Yeah, so there is this provision that says upon a showing that the information that they need to provide cannot be obtained within 30 days, they can ask for additional time. That's not a good cause exception.
Yeah.
Okay. I agree with both of those.
I mean, I just think like I do child protection appeals, and those appeals, it's a 20-day timeline. And that's short. And that's, so to me, 15 days. And especially when they don't send proof of receipt, and some agent, DHS right now can be flexible, but they may decide, oh, we're gonna, shift gears and kick out as many, that we can, or we're gonna be just much harsher on it. I also quite frankly think that, they should be sent by certified mail or personal service, just to make sure it's actually received. That gets rid of one of my number one arguments for maltreatment. I just, something to ensure the person actually gets it.
Okay. Yeah, I'm on board with all of those. So, related to that, then
This is what
is
Tashonda talked about.
what's that?
That's kind of what Tashonda, the next one.
Yeah. So as it's set up right now, the applicant is responsible for getting some information that is laid out in the rule itself, but then essentially any other information that DHS requests of them. And on all of these, criminal legal system related disqualifications, DHS always asks them to get the police report. And I don't know how much of a burden it would be for DHS to get the police report. Certainly they have the ability to get them. They're getting them themselves when they do preponderance of the evidence determinations. For example,
to me, so many of them, when you get discovery from the agency, for example, they give you the police report. So they have them.
Yeah.
They have them in their possession. And so many of them are companion criminal investigations where you look at where there's a cross-reporting requirement that they're working directly with law enforcement. To me, they have them. I don't feel like that's a burden. I don't see that as a burden, since in all reality, I've gotten them directly from the agency anyway.
Yeah. And it may be that they don't have them within the time frame that they disqualify people.
Mhm.
Actually, that makes me think of something else. But they obviously have a way to get them, and it certainly would be, it would help a lot with the individual getting their appeal in on time if they didn't have to go track that down. That's not easy to go track down. And I think, realistically, people don't often have that information. Like even with a criminal case, like you'd think, at some point they should have got it in discovery, but that doesn't mean that they got a paper copy or even had a copy. It may, be something that their attorney has that they never got.
Right. Well, I also think data practices comes into play here, where an individual, there are certain portions that may be redacted that they may not have access to, but are still part of the police report. So, if it involves, let's say, a minor and they're not the parent, even though it's about them, they may be entitled to the information that's about themselves, the person, but maybe not the other information. And so whereas I think DHS does have access to it. And so I think there's a variety of reasons why the agency should just simply provide it. And maybe it's not always readily available.
You cut out, Lucas.
Oh, sorry. Maybe it's not always readily available, but then maybe that would be grounds for an extension to respond to the request for reconsideration. Okay, issue your decision, but the person gets longer to respond until the police report's available, or, something along those lines.
Cutting out again. Is she cutting out to you, or is it my connection?
I think it must be yours, Mr. Esme.
Hmm. Can you hear me, Josh? No.
Can you hear me, Mr. Esme? I assume you can hear me, Madam Chair.
Mhm.
Yeah.
It's one of those, I guess it's Monday.
Yeah. Computers have a Monday too.
Hmm. There you go, Josh. If you're not sharing, can you hear us?
Can you guys hear me?
Mhm. Yeah, we can.
Okay. I'm hoping that was just a hiccup in my Wi-Fi. Can you hear me still?
Yeah.
All right. I'm gonna try to share a screen again. I'm gonna leave my video off. I didn't get basically any of the last like 3 minutes, Lucas, of what you were saying.
Okay. So I just was gonna say, if you can you hear me?
Yep.
Okay. So my suggestion was, I think the agency should be responsible for providing the reports. And I guess my idea I threw out was, even if, let's say, the reports are not available yet at the time of the decision, that perhaps then the person gets an extension on their time to request reconsideration until 30 days after receipt of the reports.
Okay, so DHS. Yeah, okay.
Because what I threw out was, in some circumstances, maybe there's a data practice issue where the individual themselves cannot go get the report anyway. The alleged victim is a minor and they're not the parent or whatever it might be. So, whereas DHS, I think, can.
So if I understand that right, so DHS can go ahead and they can issue their initial disqualification under the normal time frame. And then if they can't get the police reports prior to issuing the disqualification, the 30-day window for requesting reconsideration doesn't start until DHS provides those.
Mm-hmm. Yeah.
Okay. So everything in yellow is just going to be suggestions. Should we move on?
Yep.
Okay, so as it's currently set up, if you don't appeal within the window, you have waived that appeal. That is not the worst thing if you are simply requesting a set aside, because a set aside is, a specific agency decision related to an individual application and an individual job placement or position. And so, if you don't appeal it, you don't get that job, but it doesn't stop you from applying for another job and asking for a set aside in that job. It is a huge issue though if it's a preponderance of the evidence determination, because if you don't appeal and you waive it, then that preponderance of the evidence determination is considered final, and you can't raise it even on a subsequent appeal if you apply for another job. This isn't as big of an issue if we completely get rid of preponderance of the evidence determinations, which we're recommending anyway. But I put it on here because, it's possible that doesn't happen. And if that doesn't happen, then I would suggest language stating that you have not waived a preponderance of the evidence determination by failing to appeal within the 30 days.
Yeah.
Okay, so then the next ones are two issues related to DHS's response times. So the first one is the timing of the initial disqualification. So essentially the timing to create the background study. This is where I think we've seen, like, sometimes it taking just a ton of time for DHS to get that done. Like anecdotally, I've had people say that they've been waiting especially during the pandemic, like over a year, until they get like the disqualification. On the one hand, I think that often can mean people are working, and so a faster agency determination like actually sort of gives them time on the job, right? On the other hand, it can be an even more devastating loss if you are taken off of a job after you've invested months of training and all of that into it. I don't know that I necessarily want to suggest something on this point, but it's definitely something that seems like it's an issue.
Well, I also, to me, if there is a delay, to me, that benefits the individual, because the individual almost in some respects has a track record that they're not a risk of harm.
Yeah. Okay. And
time always seems to help that sort of defense respondent, whatever applicant part.
Yeah. And I if we're thinking about it, we've got both the the employer and the employee, sort of satisfied with the arrangement. And it does give, especially if you end up asking for a set aside, your argument that there is no risk to the people that you're providing services to is stronger if you can say, I'm 14 months in and we haven't had an issue. So maybe we just leave that one.
I think so.
Okay. The statute, though, does say that DHS has to respond in a particular amount of time after you've requested reconsideration. It's 15 days. If the only basis for your reconsideration is that you are not a risk of harm to the vulnerable people that you're serving, it is 30 days if it's a correctness request for reconsideration. So preponderance of the evidence determinations would fall into that. So would just I'm not the person with the criminal record that you are disqualifying me from. And then 45 days if you're making both arguments. I flagged this one. I don't know necessarily that we want to make a recommendation on it, if it seems reasonable.
I mean, I like that DHS has a certain amount of time that they have to at least respond to your request for reconsideration versus they have an unlimited amount of time.
Say that again.
So this statute, you said, outlines how long DHS has to respond to the request for reconsideration.
Right.
Yeah, and I guess I would like them to have a deadline.
Yeah, no, and they do. So it's just a question of, are we okay with this deadline?
I mean, I think I'm okay with it.
Okay. The next issue is in reviewing the reconsideration request, the statute provides this language. The commissioner shall give preeminent weight to the safety of each person served by the license holder over the interests of the disqualified individual. And it doesn't have to be that. No. Certainly the purpose of the statute is to protect vulnerable people. So I can see why the legislature went here. But, the purpose of this task force is a realization that too many people are getting screened out. So we could think about adopting a more balanced standard that weighs more evenly the interests of the employer and the job seeker.
Well, I just see, it seems like it's almost a, and I don't know why I'm having a total lapse on the right word, but essentially like a preference, but even those can be overcome. So even if it's some way that the individual, whether it's a more balanced standard or the individual can overcome that weight, just something even along those lines to kind of shift where it can be shifted back in essence.
And I mean, I think that is how it is sort of set up, right? I mean, this statute directs them to give preeminent weight to the risk of harm. But elsewhere in the statute, it points to all of the factors that they should consider in determining that there isn't a risk of harm. I don't, in the cases I've worked on, I actually haven't really seen DHS like even cite this. So I don't know, how impactful it is in the analysis, but it is a place where we could change some language and direct the agency to maybe think more proactively about, the needs of both the employers who need workers and the job seekers.
Yeah. And the word I was looking for is presumption. It almost seems like it's a presumption, but even those can be overcome. But yeah, I think, and whether we want to do that, and I think maybe that's a good topic to discuss once we have quorum, would be, is it more of an aspirational type? Hey, DHS, we really think you need to look at this, or is it an actual formal recommendation?
Okay. So we'll continue thinking about that.
Yeah.
Traveling set-asides.
I know that was an issue for Dave Irving.
Yeah, I mean, this is just a big issue in general. The idea with a traveling set-aside is that once you're cleared for like a class of job, that you can take it to the next one without needing to go through a whole nother background study. DHS, I think, does do these, but I don't know how consistent it is. It's not something that is codified that they're required to do. It's something that they, have sort of created, within, their workflow separate from the statute. This might be an area where we would need DHS's, input to help us come up with what could be helpful. But it seems to me that, our recommendation here should be to adopt language that would, that would instruct the agency to use traveling set-asides as much as they possibly can. That they're more efficient, they're better for the individual. So I would say, traveling set-aside should be codified.
Mm-hmm.
And used as widely as possible.
That makes sense.
Maybe ask DHS for language.
Mm-hmm.
How late did you want to go today? Should we get through these last couple?
Yeah, let's get through them and then that'll help shorten up on Friday if it works.
Okay. So the next one is an idea. I think Tashonda has raised this, a couple other people too. It seemed exciting to me. The idea that we could approve accessibility to the reconsideration process
Mhm.
by creating opportunities for people to do it over the phone, over video interview, something in person instead of in writing.
Mhm.
Seems like a good idea to me. I don't know that I've like thought through all of the nuts and bolts of, how to make that happen.
Right. I like that. I just think of how many clients I have who just are not good communicators. And even for me, it's like pulling teeth sometimes to get information, but there's important information to get. Or not everybody has a college education or, something along those lines that I want to make sure it's accessible. Or English isn't their first language like you have on there, or any of those pieces. Because I think, if I remember correctly, I think some of it says, if you'd like these forms in another language, you can go here. But somebody has to know enough of what they're looking at to actually get to that point.
Thinking something like a hearings officer for like
Mhm.
traffic tickets and stuff.
Mhm.
Okay. So this next bullet point right now, DHS on their set aside requests has a really nice paragraph where they say you can have an attorney and points people to Volunteer Lawyers Network and some other community resources. This is just another thing where I'd like to sort of codify what the current agency administration is already doing well.
Mhm.
Okay, this last one is another one that I don't know if we're gonna have a recommendation on, but I thought it was worth flagging. It's also something that matters a whole heck of a lot more if the preponderance of the evidence determinations don't go away. But as it stands right now, the rules of evidence that apply in contested case hearings are incredibly broad, much broader than that site did not work. Much broader than you would get in a criminal trial. So it's basically anything here. I'll find it.
Reliable. Are they the similar where reliable hearsay is allowed? And things like that.
Yeah, it's admit and give probative effect to evidence which possesses probative value commonly accepted by reasonable prudent persons. So it's like anything as long as it would be reasonable to rely on.
Which, sometimes as an attorney I use to my advantage.
That's true. But
but that's something just from using it. Well, and I also wonder, like a lot of these, they're not really making people available, let's say, for cross-exam or things like that. But that's where just even if more people had access to attorneys for these, maybe the process would just be better or work better or whatever it might be for individuals.
Right, but even if you have an attorney, without the rules of evidence, I don't know, I can't get this to work. Even without the rules of evidence, the agency can, in a domestic assault, present the allegations that were made against the disqualified person without having that person appear, right?
Mm-hmm.
Or, I did administrative law hearing years ago where it was this disqualification based on like 30-year-old police reports. And in those police reports, it was like a incident that happened in public, and there were a bunch of people. It was in another state too, and it was a bunch of people that we had no way to track down that had all made comments to the investigating police officer that then were used to uphold a permanent disqualification. even though they're clearly hearsay and would not have been allowed in a criminal trial.
Right.
There's also the issue of evidence that would otherwise be suppressed because it was obtained in violation of your Fourth Amendment rights. The exclusionary rule that says that can't come in a criminal trial doesn't apply in the administrative hearing necessarily either. So I don't know that we should go ahead.
I don't like, I mean, to me, I struggle with, especially if something, let's say, was suppressed. Like that's suppressed for a reason. To me, that's problematic that then it would be allowed here. I think though, the statute, when you went to it, did talk about stuff that would not be admitted. Incompetent, irrelevant. Well, then to me, I suppose the argument would be if it's suppressed, it's incompetent. I don't know if there's case law or if that's defined somewhere, but
yeah, I'm not sure about that. Okay, I can try to look into that before we get to Friday.
okay.
And again, this might not be an issue if we adopt a recommendation that we get rid of the preponderance of the evidence determination, because
Right.
then we're not fighting about guilt or innocence in front of an ALJ at that point.
Right.
Um,
And I see what you mean. That may make sense because then, we're really looking at the cases where somebody where somebody was convicted or did enter a plea versus that preponderance of the evidence. So yeah.
If anything, the existence of this issue is a reason, contributes to our recommendation that we should get rid of the preponderance of the evidence determination entirely. And then the last one, this one isn't exactly, I don't think, a process thing, but we haven't addressed it yet. And I think it's worth thinking about because our current recommendations are that we continue to disqualify people based on a stay of adjudication. That leaves this weird catch-22 where for some types of cases, like low-level felony cases, it could be better to get a stay of imposition of a sentence where you're convicted, you're sentenced, but after you complete your probation period, it gets downgraded to a misdemeanor. That creates a shorter DHS disqualification length than would a stay of adjudication, which is a disposition where you're not convicted at all and is sort of universally within the criminal legal world considered a better disposition.
And Josh, I just don't remember this. So I don't even remember the answer. If you get, let's say what would normally be a permanent DQ, but you qualify for a stay of imposition, does that take you off the permanent list?
Yes. Well, it depends on what it's for. There are some things on the permanent list. There are permanent disqualifications no matter what the disposition level, but there are others that it says only a felony conviction is a permanent disqualification. And it may be worth clarifying that with DHS, but I think the most natural reading of the statute would be that with a stay of imposition, you trigger the language at the end of each section, that tells you to look, not to the charge level, but the disposition level.
Yeah, it's funny you bring that up. I actually have a case right now where we're filing for somebody where it's a crim sex, and according to the sentencing order, they qualify for a stay of imposition. Maybe I'm just curious now for personal reasons.
Yeah, so I mean, it can create, so if probation is recommending a stay of imposition, you're talking about the PSI says they qualify for a stay of
No, the sentencing order so that once probation is done, they would get the stay of imposition.
Oh,
It's already ordered.
yeah, so they got a stay of imposition.
Well, but it's not because they're not done with probation yet.
Right. So with the stay of imposition, it's like it's considered a felony while they're on probation, and then it is deemed to be a misdemeanor once they complete probation.
Right.
Right. So so yeah, once they complete probation, it's going to be a misdemeanor conviction and it will be a 7-year disqualification.
Interesting. Okay.
Wait, it's crim sex though?
Mhm.
I think crim sex is permanent disqualifications no matter what.
That's what I thought, which is why I wasn't sure if it's ultimately deemed a misdemeanor.
So yeah, where this would matter is stuff like here, a felony offense under first or second degree.
Mhm.
And if you look under 7-year disqualification, you still have assault in the first degree, assault in the second degree,
Got it.
contemplating that you can have a misdemeanor conviction for those felony charges.
That makes
But I'm pretty sure all the crim sex stuff. Yeah, so criminal sexual conduct.
Stays up there.
Yeah.
Okay. The stay of imposition sometimes under some of these statutes gets a little confusing. So, yeah, and so, okay, so what are we saying as far as stay? I took us down a rabbit hole. I'm sorry.
No, that's okay. I think my recommendation here, or my suggested recommendation, would
Mhm.
be that we continue to disqualify people for stays of adjudication.
Mhm.
Because that was a compromise that we thought was important to getting rid of preponderance of the evidence determinations,
Mhm.
but that the disqualification period be for the misdemeanor, be the same as for a misdemeanor level disqualification,
Okay.
or whatever the lowest level disqualification is.
Okay.
All right, so I'll email this out to everyone in the subcommittee,
Mhm.
and we'll see if maybe we can meet briefly on Friday to finalize.
Yeah, that sounds good. I'm just double checking quick from our initial recommendations back from February. That's what I've been looking for here. Just to make sure there wasn't something. Management. I think back from our very initial, back in February, I think we're pretty spot on. The only thing which I think we technically covered back when we looked at our initial buckets was the current process where it looks everybody is lumped together the same, whether you're, let's say, a maintenance staff versus an actual, let's say, caretaker. So direct versus non-direct care are treated the same. But I kind of think with our original recommendations back from early on with treating people differently based on which background study they actually need, maybe covers that.
Well, so these are the risk of harm, like set aside factors.
Mm-hmm.
It's interesting. I thought it was listed in here, but maybe it's just generally on any other information relevant to reconsideration. I'm pretty sure the worksheet.
Pretty sure it does ask about who you serve.
Yeah. Well, so there is the similarity between the victim and the person served. So that question asks, something about the person served by the program. But at least on the set asides that I've helped people with, we'll often talk about like the level of supervision, the level of access, like those types of things.
Mhm.
So maybe aren't you minimizing? Sorry, I'm struggling with the Zoom windows.
That's okay.
Something like in the risk of harm analysis, DHS should consider how much supervision and how much access
Mhm.
the individual will have, or
Yeah.
the duties of the individual position will require.
Yeah. Because I do think, if you're, and I think that was something, forgetting the name of the individual who brought it up, but that was important for somebody.
I believe that was Mr. Hanson.
Yes.
Madam Chair.
Yes. I think from the employer perspective of if someone does not actually have access, they should be able to employ, they should be able to have that say, essentially.
Okay. Anything else?
I don't think so. I think let's see if we can get Friday to work, and then let's see if we can finalize some of this so that then by October 7th or whenever it is, I would presume I'll probably need to go through and kind of re-present to everybody sort of all of our recommendations that we've done.
Yeah, that's going to be a long meeting if all the subcommittees have to recap a year's worth of work, but
Yeah, well, and then that'll hopefully give me some time to put it together.
okay.
Okay, sounds good. Thank you, Josh. Thank you for looking at all of this and all the links. That's super helpful. Maybe if you could send that over to Will, and then Will, if you could distribute to the group, that would be helpful so that everybody's ready to go. And hopefully we can meet on Friday and get this finalized. And yeah, well, if you could just let people know, like 30 minutes, just short, let's get through this and try to finalize.
For what it's worth, I'm pretty flexible on timing on Friday too,
Okay.
if that helps.
I actually haven't looked at the itinerary for the CLE, so whatever.
That's like 4 days from now, so
I know, I got so many things before then. I'm not even worried about it.
I hear you.
So yeah, so that sounds good. Thank you very much. Thanks for going longer today. And hopefully see everybody on Friday.
Okay, see ya.